Okay, welcome everyone. And today's topic is more about the RFE and denials, what went wrong in the very first time when the petition is filed, and how to recover them. I bought some real case studies of the evidence and the denials that I do see every day. So let me introduce myself to everybody. I'm Svetlina Barek. You can call me Swati. And we have like Michael today, but unfortunately, he would not be able to join the session today. I usually work with lots of attorneys in making sure that the denials or complex issues that we are like facing is like coming up with a good strategic understanding. So I have bought some real time cases with you. So I'm going to share my screen and share the share the document that I have prepared, and you can take some key takeaways from here. Feel free to ask any questions if you have. So there's like, we have seen that these days there is lots and lots of denials are coming, right? And because of the same, everybody asked me same question is this. Okay, out of 10 criterias, I'm filing 5 or 6. Out of them, it's getting approved as well. But at the final merit determination, when the approval part comes into the picture, after the RFE, it's not getting approved, it's getting like a denial, or they are asking that I'm not completing the two-step Khazarian theory that the USCIS has put to it. So everything situationally belongs to the positioning of the petition. So today I'm going to share with you how the part 2 works for EB1A, for EB2NIW, and for O1. With that, I have also bought some kind of common as well as key takeaways from the NOIDs or the RFEs that I'm looking through it. Okay. So let's start with the EB1 part. So what is happening at USCIS right now is very different. So right now, a successful petition or a successful professional is very differently seen as the extraordinary ability. Okay. So previously, it was a very different theory getting used, or you can say a little bit a different way of being seen. But right now, they are like differentiating between, okay, if this particular profile is very good, have achieved a certain way of success, but whether that particular profile is also achieving the extraordinary targets that USCIS has benchmarked for EB1A. So I'll go through it, each one of them, and explain. So there is no law change for EB1, O1, or NIW. We have seen since the new administration has came in. So what has shifted is the way officers read the evidence. They are slower to give credit. They want to see proof of impact, not a description of a job. 3 patterns are showing up across most of the cases that I have been reviewing. So it's just not even about giving slower credit, but it is also wanting to see the impact of your work, just not on your, on your company or in the, curated organization, but to your domain, the impact on the domain. Okay. So also the recognition and impact both go hand in hand. So the comparable evidence question. Officers are asking the petitioners to explain in writing why a piece of evidence should count toward a particular criterion, which it does not match the textbook description in the regulation. If you're submitting an industry award, you need to walk the officer through why that award is recognized in your field. Do not assume. So I give you a very small example. This example I've given like you for like an award, but a real-time example I'm giving you. So a person who is actually a senior professional, and he's a data analyst, right? And he is working in like generative AI and ML domain. So what happened? He has filed his EB1A, okay? And now he received a RFE. So he has done amazing hackathons and judging of peer reviews from IEEE, and to make sure that he's coming along to the sustained acclamation and everything is there. What went wrong in his petition is something unusual. So we have to make first understand whatever domain we are choosing or whatever domain we are working in, every evidence that we are like trying to build towards, it is bouncing back to the same domain. So we have to explain each domain. So for example, if you're doing a peer review, okay, so you have like you are IEEE senior member and there is lots of events happening in the IEEE Explore, etc. So you were invited to like become a peer review of a particular document, right? You you started reviewing it. So it's very important to showcase that why that particular topic is related with your domain and why you choose that topic to review it. That's how the correlation is maintained. We cannot say that, okay, a bunch of 15 or 16 peer reviews we did, and we did under the computing technology, and they will understand that, okay, this is how it is. Now things has been changed a lot. So every evidence that you are corroborating and trying to figure it out, or you're performing, you have to make sure that it is making complete sense with the domain and it has to be explained in the petition very well. So, and when you are also doing peer reviews, one tip from my side is this. You also have to make sure that you are giving a descriptive understanding of that particular paper. That's called like judging. You become a judge and then you're reviewing that particular paper, right? So, how would you scrutinize that paper is completely up to you. So, I also, we also see that we are also using that comment or your reviewing of the paper, the sections that you are reviewing, or the paper that you are reviewing, that complete comment that you are giving them, that is also being used as an evidence. So please make sure that whatever you are doing is maintaining the evidence. While you're doing a hackathon, you're putting a scorecard sheet, like, right? You are becoming a judge and you are like becoming a judge in the hackathon event of a professional or a college group of students in the technology field or however it is. So please make sure you are putting a screenshot of the score sheet, or if you are, you can ask the organizer to share the score sheet. That score sheet is also makes a lot of big difference in showcasing that yes, being a judge, you have like scored these people, or this was your score on that particular event. So one of the understanding of mine is one of the evidence that we can show is that how you are evaluating that particular event, that particular paper, etc. So that's the reason where each evidence or criteria that you are like, vouching for, it should bounce back again to the domain and should correlate and async with why it was done. Now, next is the sustained acclaim challenge. So in EB1A, a single award or a single publication is rarely enough. Officers want to see a pattern that stretches across the years. One paper from 2019 and one talk from 2024 reads thinner than 5 steady moments of recognition between 2020 and 2025. Okay, so over here, it depends upon what is your anchor criteria. Your anchor criteria cannot be all the 5 or all the 6 that you have decided. Your anchor criteria would be only 2 or 3. Sometimes it's also 1. It totally depends. So, for example, if you see that your anchor criteria is original contribution or a critical role, and you're a tech industry, so definitely out of 2 of them, one or both of them would be the primary criteria to be anchored. Then the sustained acclamation chain part from the anchor criteria, right? So your experience is your anchor criteria. So the complete experience part of what you've been building in the original contribution, what was your contribution towards the original idea and execution of it, how many years you've been into that particular domain and stuff. So here, when there is an authorship article, it is more about, that person is a researcher or from a researcher background. So there is a different way of shortlisting the criterias. We can't say that, okay, if I am a technology person or I'm in a tech area, so I will choose my primary criteria as a authorship. It doesn't works like that. It can be a part of it, Yeah, it has to be because there are 10 criterias and you have to make sure that you are coming and falling under three of them. But you have to make sure that which criteria to target first, which to target second, which to target third, and which to target fourth. Likewise, random alignment would not make a better understanding on the petition because it's not just checklist or checking the criterias out, it's more about narrating your own story to the USCIS. So to make sure the narration is going nicely or making sense to them, you should be able to understand that what should I pick up as my primary criteria, as anchor criteria, which will rule the whole petition towards it supporting the other criterias. Okay. Likewise, both the anchor and supportive criteria meet together and place it to like three or four criterias. That's how it works. The closer read of recommendation letter. Generic letters carry very little weight today. If a letter could be copied onto another person's case with only the name swapped, the officer will treat it as a background noise. The letters that move the needle name the project, name the outcome, and name the people with benefited from the work. In my previous webinars, I have been talking a lot about the letter of recommendation and also giving a lot of weight on the letter of recommendation because it really plays a very vital and important role on your petition. It's very, very important to precisely choose who are the recommenders who can become a part of your petition, why you are choosing them. So you cannot like choose it randomly. You have to make sure that okay, they are like impacting the domain and why you have choose them to write it for you. And it can be very simple. Somebody who is your manager and you have choose them. If somebody is, yeah, your manager and you have choose them to write it because they are closely working with you, right? And they are aware more about you, what you are working under, what project you are working in, etc. So that's the reason why you are choosing. But you also have to be very constructive in writing. So please be very precise with what kind of projects you want to show, what kind of statistics you want to show, what kind of metrics you want to show. And it should be weighted. It cannot be like a simple experience letter. There is a way to write letter of recommendation when preparing for extraordinary ability. You're building your case around it. So be very precise and also narrate your letter of recommendation. Not like, okay, I have original contribution, critical role, so let's put all the letters in the critical role. No, not like that way. Any criteria can demand an expert letter. Any criteria can demand a letter of recommendation. Needed to be identify the positioning gaps. For example, if you're doing a judging criteria, okay, and you've been trying to do it and you have completed your judging events or something, yeah, but you could not find one or the other evidence to substantiate or strengthen that particular judging criteria. So in such situations, letter of recommendation plays a vital role. So these also does not only anchor or become a primary evidence. Sometimes for other criterias, these are also coming as a supporting evidence. So this basically is an art. You can place it anywhere, but you have to make sure that if I'm using this letter, what part of evidence it is supporting to my, the whole picture. So let's take an example, a very short example I've tried to like formulate here. So it's about a EB1A case study. So it's a applied machine learning, the field was, and he's a senior ML engineer at a fintech company. And he was having 8 years of experience. So initial criteria claimed was original contributions, scholarly articles, and judging. Okay. So we did claim the critical role as well, but it was like the fourth point. So outcome of the first review was RFE on all the three criterias. What was filed? So the petitioner had 2 granted patents, 4 conference papers, and 7 recommendation letters. 6 of the 7 letters came from the former managers or close collaborators. The petition argued that the patents alone provide proved original contributions of major significance and that judging was satisfied by satisfied by 2 paper reviews completed for an industry conference. So, what the officer wrote in the RFE. On original contribution, the officer noted that holding a patent does not by itself establish that the work has influenced the field. The officer asked for the evidence of adoption. Okay, so most of the time when you have a literal patent, okay, so this needs to be like adopted by a company or by an organization, or it's been used, or yeah, it has to be like used. There is a different, like there is like this is EB1. When I'll come to NIW, I'll tell you something different about patent, how it can be used. Any kind of independent recognition needs to be used. Only a certificate would not be much helpful towards it. So a lot of time I have seen that, a certificate itself, they come along and then it's like a grant certificate or an application which talks about it. But that just does not make sense. Recently, I'll give you an example. One of my client that I was talking about, that how that domain positioning got skipped, he also had a patent, and his patent was widely recognized because on that patent, the academicians were started researching and writing articles. So such kind of evidence we can also show. So the patent is there, and other people, other companies or organizations are rerouting to that, started researching about it. Academicians started researching the angles through that patent. And then we can definitely show the impact like that way as well. So this is just not the only the adoption letters or citation or independent recognition. Yeah, but also somebody else is using that particular patent. That also makes a lot of sense. On scholarly articles, the officer accepted that publications existed but questions whether the venues qualified as major in the field of applied machine learning. As I said, whatever the topics is chosen for your authorship, you have written for your authorship, make sure the petition does contain, make sure the petition itself has mentioning about what that scholarly article is talking about, how it is related with your domain. This is very important. We cannot leave by saying that officer will assume that it is what it is. No, that's not possible anymore. You are the subject matter of the expert. You have to showcase that in the petition itself. Why I have chosen this particular topic. Why? And why, how it is related with my domain. On judging, the officer wrote that reviewing 2 papers for a single conference was not enough to demonstrate participation as a judge of the work others as a sustain. Yeah, this is very natural that you cannot just have 2 papers reviewed and submitted as a judging. You must show like, more papers and other stuffs that you've been doing to showcase that, yeah, you have a subject matter expertise in that domain. 2 papers won't be that great idea. So what went wrong? The original petition leaned on the resume. It listed achievements without connecting them to industry impact. 6 letters from people inside the petition's professional circle made the officer wonder whether anyone outside the circle knew the work. So please, when you are arguing your final merit determination, try to bring out the independent expert letters. Somebody who is not in your company, but who knows your work, have heard about your work. In the colleagues also, like you're going to a conference, gelling up, and you get a chance to meet with somebody. And since then you are like, speaking on front of the work. These, please try to get those hold on those people who can write up an independent letters for you. That actually enhances the petition, and also creates an understanding that people recognize you beyond your organization. That is very important. So the response moved in 3 directions at once. The team found that one of the patents had been licensed by another company in the same sector. They obtained a written confirmation from the company and submitted it as an exhibit. So this is very exceptional. Usually, I don't see that happening, but it was in that case. So this is how we have resolved it. Then they pulled citation data from Google Scholar and Semantic Scholar showing that the petitioner's papers had been cited. Researchers Stanford, MIT, 2 industry research labs at the officer would recognize. So this patent was a long back running patent back, I believe, like in 2019 or before that, 17, 19. And it was like easy to fetch because if a patent is longer stated there, so it is easy to like, fetch the understanding of it's easy to like adopt because the more patent is there in the market or in the public domain, the more acceptability comes into the picture. That's how it works. And for patents, it definitely takes a lot of time for the acceptability and adoptability. They expanded the judging evidence by submitting records of the peer reviews the petitioner had completed for journals over the previous 4 years, demonstrating a pattern rather than a single instance. Yeah. So it was not submitted before, so we have to like showcase the previous ones and then we tied up together and then it went along. So they also replaced two of the weaker recommendation letters with letters from independent experts. These new letters did not just say the petitioner was talented, they explained with specific how the petitioner worked and shaped the projects at the other companies as well. So many a times I have seen that senior professionals, high skilled professionals who are having like more than 8 plus years, 10 plus years of experience, or 15 plus years of experience, they are working in a company, but they are also helping to set up, new startup companies for the founders, give them the advisory councils and others advisory, being an advisory body or a committee member of it. So definitely it helps in posing or positioning them in their own EB1. So the case was approved approximately 3 months after the RFE was filed. And USCIS does not just want to see what the petitioner did, the officer wants to see how the field responded. Build the evidence of the response to the record before the RFE forces you to. So yeah, definitely you should be able to focus on two things whenever there is a response. Number one, how's the impact? Number two, how's the recognition? These two are very important on for EB1M. Now let's go ahead with the O1 case study. So the field was product designing and lead product designer at Series B startup H1B with one renewal remaining. Press original contribution, leading role, and judging was picked up because he was having already some of the stuffs in rolling out on his name. So we decided that we're gonna do around it. Outcome of the first review, RFE on press and consultation. So what was the field, what was filed, sorry. The portfolio was very strong indeed because in products, things become stronger. So the petitioner had shipped design work of two consumer apps with millions of users, had given a regional design talk that was viewed widely on YouTube and had been featured in two design publications. The advisory opinion came from a single industry contact rather than a recognized peer group. So what the officer wrote in the RFE, the officer questioned whether the cited press articles qualified as a major media. This is something which is literally making sense right now. Right now, either USCIS is rejecting the press or they do want to understand how the press is being cited, who is the target audience specifically, and whether that press is falling under the major media or not. One of the articles was from a small design blog. Please do not use medium or kind of blogs. It is not worth it. It's red flagged. The officer also flagged that no peer group consultation had been included, only a personal letter from an industry contact. So this RFE was lighter RFE. It could have been solved, but there are some things. So when you are planning or you already have a press from your company or your own startup and something like that, I don't think that writing blogs is really helpful or can make a difference in your press criteria, like blogs, like medium blogs and stuff. So please make sure that you are not using the blog idea as a press media component. What went wrong? So they assumed that any published article would count under the press criterion, as I said. They had also treated the consultation requirement as a soft step. For O1B in particular, that is a mistake. The consultation is not a friendly cover letter. It is structured opinion from a body that speaks for the field. So in O1B, you can be very short but very precise. The response narrowed the press evidence rather than widening it. Sometimes you also have to see like this. Okay, the officer is giving like three, you have filed like six criterias and you received four criterias in RFE. So you have to also make sure that whether you want to respond in all, if you're responding, how to respond, discount some of the components, how to mitigate it. Like blocks cannot be a part of it. So in this particular thing, they have just removed the blocks part. Two of the weaker articles were dropped, as I said. The remaining publications were supported with circulation numbers, the media traffics, monthly readerships and editorial standards, a news feature interview that had been published while the RFE was pending. We can add it. We cannot add something, we can definitely add some new components or evidence while the RFE is there. But please make sure that you are discussing this with your attorney and understanding whether that can be addable or not. On the consultation point, the team obtained a formal advisory opinion from the particular organization, which is recognized professional association in the design field. The single document carried more weight than the rest of the response combined. So on O1, the consultation is not a formality. When the petitioner works in a creative or a design field, USCIS expects an opinion from peer group that has standing in that specific community. Plan that step very early, not like just one single, letter would help you. Now let's talk about NIW. Right now, NIW approval rates are very less, almost 36%. Let's see. So the field was cybersecurity research, senior researcher at a federal contractor, PhD, 12 peer-reviewed papers, protection of a critical infrastructure, got denied. So what was filed? The petition argued under the, obviously as more about the three-pronged test, that the petitioner's work had substantial merit and national importance because it protected systems used by the federal agency. The technical sections of the petitions were dense. Usually NIWs are always dense. The connection between the research and the national interest was assumed rather than spelled out. What the officer wrote in the denial is very specific here. The officer accepted that the field of cybersecurity has substantial merit. Yes, it has, but was not persuaded that the petitioner had a track record of success that suggested future contributions or national importance. Always remember, when you are filing an NIW, you have to be very cautious how the impact is on future. O1 or EB1A doesn't need what's the future. It does need an FMD, but the whole NIW thing revolves around how you will position yourself in the future. Okay, that's the reason why it got denied, because it could not make a proper track record of success that suggested the future contributions of national importance. The denial did not say the work was unimportant. It is obviously not, because it was coming under, the security, cybersecurity, it's a national importance. It is said that the file did not show that the petitioner specifically was the right person to advance it. What went wrong? The original petition described the researcher in language that an officer without a technical background could not parse it. It assumed that the federal agency connection would speak for itself. It did not. As I said before, connect every evidence that you are building to the domain that you wanted to talk about. The recovery, the team filed a motion to reopen and reconsider with three new categories of evidence. You can also refile it. Please speak about this with your attorney. What would be the best option throughout it? A letter from a senior official at the contracting agency confirming that the petitioner's research had been integrated into a deployed system used in the active operations. A plain language explanation of technical contributions with simple diagrams showing how the petition's algorithms reduce the false positives in the threat detection. So there was a missing technical document, which shouldn't be the case, but it got missed. Two letters from independent experts who had no prior working relationships with the petitioner. These letters discuss the broader implication of the work for the cybersecurity field. It totally depends whether your attorney is inclined towards filing a motion or whatsoever, or inclined to file a refiling. Okay, it is between you and your attorney. Please have a very, open discussion about it whenever such situations comes into the picture. For NIW, the burden is not just to prove that the work mattered. It is to make sure the officer reading the file can understand why it matters and why this particular person should keep doing it. That's called national interest waiver, something which is interest of the national. Plain language wins. Okay. So some things that I have just figured out as in total. Different categories, different facts, but the same lessons keep appearing. Outside recognition is more persuasive than just internal praise. A licensing deal, a citation from another lab, a feature in the publication, these matters more than 5 letters from your direct managers. There is more into it. It's just I've given some examples. Specific beats, adjectives, a letter that names the project, the metric, the people who benefited carries weight. A letter that calls someone brilliant carries almost none. So letters like, oh, he has done very good job, kind of a experienced letter doesn't works. The letter must have depth. Basically the recommendation letter. The plain language helps the officer reach the right answer faster. Technical density is not a virtue when the reader has 15 minutes. See, over here it is a catch. Don't think like you cannot put the technical substance into it, but it also has to be very fairly understandable. So language makes more sense, and very precise language, very simple language, but also the technical aspect of things are like actually conveyed properly. Sustained patterns matter more than isolated peaks. Officers are looking for evidence that the recognition is ongoing, not a single bright moment from years ago. Consultation and peer group standing are not paperwork. For ONB in particular, this can decide the case. So it depends upon case to case what should be the right evidence. How to like fix a RFE response. So read the RFE twice and slowly. First 2 pages of RFE is mostly about what you have filed, what this visa says and stuffs. And then you should read it twice slowly, because every time you read, you will understand, okay, this meaning something else. Most RFEs are not random. The officer is asking specific questions. Identify each question and write it down in your own words. If you cannot summarize the concern in one sentence, you are not ready to respond. It generally looks like this way. Very simple tips to read the RFEs, like they will specifically be one sentence in each criteria if it's falling apart. So we have to just pick up that one sentence in the whole, for each criteria. Step 2, mirror the structure of the RFE. Organize the response in the same order as the officer's questions. If the RFE raised 3 issues, the response should have 3 label sections. Make it impossible for the officer to lose the track of where you have addressed each concern. It should be responded in the same way the RFE has given. Step 3, lead each section with the strongest piece of evidence, however you and your attorney decides. The first exhibit they see in each section should be the most persuasive one. Save context and supporting documents for the later in section. Step 4, revisit the recommendation letters. It's usually recommended. You can revisit whatever you have submitted, add some more components into it. It depends if something additional has been asked, so there can be an additional letter of recommendation added. In most cases, the original letters were the weakest part of the file. Updated letters that respond directly to the officer's questions written by the people whose names the officer will recognize can change the trajectory of a case in a single round. Step 5, resist the urge to overfile. Sending 300 pages when 50 would do is not a sign of a strong case. It is the sign that the team did not know which 50 pages mattered. Restrain. Yeah, it means that let's keep it very precise. Let's keep it like if something can be done in 100 pages, keep it in 100. Let's not overwhelm them with 300 plus pages, because for a fact that we have so much of material to show. Just be very precise when the RFE is in the picture now. As I said, there are 3 ways of how you can like respond to the denials: motion to reopen, motion to reconsider, refile with a stronger record. Totally depends upon you and your attorney, how they would like to pursue. Okay, this is how currently the situation is going on. I will stop sharing my screen, and I can share this particular document with all of you, and you guys can like read through it whenever you have time. We have some questions. Okay, so Muru is asking, let's say if a candidate has decade of experience, and how does USCI seem if more than of the profile building is in the last 6 to 12 months of time frame? So it totally depends upon, Muru, how you're positioning your criterias. So sustained acclamation doesn't only comes with, okay, if you are just keep doing 10 years of authorship articles, that is not possible. It depends upon how the petition is being narrative. So if you're putting your original contribution or critical role up front, then the narration steps like that way. The acclamation part comes the sustained, like you are in the same field for the 10 years, so it's already a sustained acclamation, but needs to be narrated and pictured in certain manner. So usually I won't say that, you cannot still your experience is a part of your profile building. So you are not jumping from one experience to another experience. You are still working on that same experience, same domain. So that's a part of it. So, okay, first 5 years of your working in like a healthcare sector, and then after that you have jumped to another sector, then after that you jump to another sector. Then this is a different story altogether. But you are like working together for a longer time period in the same. So that's also called building of the profile for that same length. Okay. So it totally depends upon how you are structuring and which criteria you're coming together. So it's basically how you are narrating and projecting all the criterias. If you're coming up and saying that, okay, I just wanted to go with these four criterias, that is called original contribution, critical role, maybe judging or press or high remuneration, however it is. So it totally depends, right? So how you are positioning your profile into a certain manner. Could you provide insights about the current approval status for EB1A? Yeah, it's like 66.6% at this point of time. Of direct approval and approval after an RFE response. It's 66.6, including the RFE response. So there is no bifurcation of how a direct approval is coming and after the RFE or NOID is approved. So a total, I understand that's a 67%, which is pretty much equivalent to the last quarter. Can we get access to this doc? Yeah, definitely. I can share it. Who prepares the case? Is the attorney, or how does the process work? Yeah, attorney prepares the case. They are the ones who prepares the case or strategize the case. There are always immigration strategists around to just help out, but attorney and their team prepares the case. I'm so sorry, I'm giving the access link. I believe now you can open the document. So high salary criteria and related evidence. Yes, high remuneration totally depends on the geographical demographic place where you are staying. Okay. And your last 6 months of salary slip, your 3 years of pay stubs. If you have stock certificates and a part of it, please put it out. If you get bonus and bonus stuffs needed to be added, and then it will be compared with with the same you can say with the same designation in that particular demographic area, and then it is seen that are you coming under the top 10% of the higher remuneration or not. So it's just not that, it's more above beyond that. We have to compare it with the other same designation or related the JD people who are doing. So it usually comes up to a picture. If you're falling under those 10% of the high remuneration, then you can argue the high remuneration criteria. Your attorney or your paralegal or a team of paralegal will help you out with that. Yeah. Yes, Muru, you can unmute yourself and ask.
Awesome. Thanks for. I'm sorry, I couldn't put more on the detail of the question. So when we talk about the high salary, so let's say, for example, if a candidate salary, if the candidate salary is, let's say, at par in the top 10 percentile from the Department of Labor, would that be sufficient, or I mean, what's your take actually? Or we still need to get compared with third party, surveys or what stuff like that?
Yeah, reports needed to be shared. A comparable report needed to be shared. It was like easy to get a approval in by the last year. I have seen, but I have seen that they are now have asked. So USCI has changed their rhythm and their, way of understanding on EB1 in every quarter, that I understand because I extensively work on the complex RFEs and NOIDs. So my understanding says this. that now what they're expecting, just not the OFC website and O.NET Star things that has been already there, like you are like going beyond phase 4 of your level 4 of the particular designation, but they also wanted to understand the comparison among, comparison among the other designations, sorry, comparison among the same designation in the varieties. So this needs to be compared properly and then come to the picture. So comparison is now one of the most important part, where they are looking into it, and they wanted to see it, that if we compare with the same designation with the different ways, then the reports needed to be come into that picture. So reports are one of the preliminary, or I can say primary part now they are addressing as an evidence.
Okay, I'm sorry, I'm going to stop after this. So your recommendations for a candidate is only if they fall in place in the top 10% percentile, is it? So, or let's say for somebody falls between 11 to 20, would you still consider to climb to or it's out of the window?
Ideally 10% is the threshold, okay? But if you're falling under 11 to 20%, see, a high limit is something I see it is like either you are in or you are out, and we know the result. So if you're falling under the 10%, then it's okay. If you're falling between 11 to 20%, chances are that you will not be getting that into the high remuneration. So it will either come as a RFE or they would not consider it. If you get an approval, then your approval will not based on that particular high remuneration. If it is argued, it will based on the other criterias.
Awesome, thanks much.
Thank you. All right. Anybody else has any question? Perfect. We don't have. You can still, how long before we need to respond to RFE? I believe you're asking me, Raj, that how much time they give you to respond to the RFE. It's usually 60 to 90 days. Highest amount of time they would give 90, and 60 is the minimum that they would give. For a NOID, they give a response timeline of 33 days.
I also want to know, like, does your company help in filing and petitioning?
Open Atlas doesn't do that, but
Yeah.
you can like email Visa Architect.
Okay. Okay, that helps. Thank you.
Ganesh.
Yeah. So how do you know like which domains qualify for EB1 and which do not? Like I have software engineering background, and do you think like we have worked on a lot of like open source and open API side, but how do we know like if they treat this as a domain that could be applied?
So EB1 is not domain based. EB1 says it's an extraordinary ability. So an extraordinary ability can be found from anywhere in any domain. It just need
Okay.
to be proven in certain manner. So I believe that whatever you said about the open source and stuffs, it needs a actually consultation to understand where you fall, right? For example, if you're saying me like you have like some open source work that you have done, so we can like speak and understand how the original contributions are falling, how the critical role is falling, how many years of experience you have, and all those things. Then only we can decide whether it's a eligibility of for filing a EB1A or not, or if it is there even 30-40%, how much work is needed around it. Then you can like
Got it.
plan it accordingly.
Got it. Thank you.
Yeah, I think I would also like to know, like,
Okay, you got mute.
sorry, yeah. No, I was just saying, like, to your point mentioned, to the point you mentioned about consultation, I think I would also prefer doing that just to understand how much eligible I would be and how much work can be done. So, definitely, yeah, that's a good option.
Yep, feel free to email me and I can route it to the correct department, and then they can take it, and then we can speak about it, that how much is eligibility, is 30-40% is there, or 60% is there, or is it doable or not? If
Yeah,
doable, how to plan it. Yeah.
yeah, that would be my question. Like for our next 1 year, how much I can put in, and if it's doable, then the figuring that out and some guidance on that would be really helpful. I'll reach out definitely. Thank you.
Do RFE response come in at any priority from USCIS? What would the response time from the USCIS look like if we apply with priority? Okay, I did not understand the question. If you are still here, Raj, would you unmute yourself and explain me?
Yeah, my question was, say, if we apply on a priority for, say, EB1A, USCIS responds in 20 days, right? and we get an RFE and we respond to the RFE,
Okay.
how long would USCIS take to respond to the RFE? My question was specifically because is RFE a way for USCIS to push down the case where they don't want to adjudicate soon? Is it a delay tactic?
Okay, you mean your priority means your premium processing, right?
Premium processing, sorry, that's what I meant.
Okay. All right. So see, in the premium processing, you're filing within 15 to 45 days. Now the range has been extended to 15 to 45 days. You get a response, and if you get the same timeline, so the response will also come within the range of 15 to 45 days. The RFE response, it won't go beyond until and unless there is some administrative delays from that side.
Thank you very much.
All right. I believe that we end the question. Okay. Thank you so much for being here with me, and we'll see again on 30th. Now I will have Nusrat with me speaking about some amazing topic. Till then, just take care. Bye-bye.
Thank you, Suri.
Thank you.
Thank you much.